Welcome to Frank Bruno Law. I am Frank Bruno. I'm going to finish my my story. Yesterday I spoke with a prospective client about estate planning documents, and she related a story to me in that she was a Queens resident, New York resident. She and an ex-husband had gotten separated here in New York, and the gentleman moved down to Georgia. And while there, I don't know the period of time, he got an attorney and he completed the divorce documents. So what that means is that took the separation agreement on consent, converted it to a divorce. In the separation agreement, I haven't read it, it was explained to me that the house owned in Queens, he was going to relinquish any ownership interest in the property, and it would go to his wife, right? Then ex-wife. Now, when you do something like that, it just doesn't happen by magic. It doesn't happen automatically. It doesn't happen like it's not self-executing. When a person says, I'm going to relinquish, all my right, title, and claim in a property, you then need a deed. And you need transfer documents to go from husband and wife to just wife, right? So husband and wife to now single person. And that was never done. So when the husband secured the attorney in Atlanta, did all of the paperwork, she signed, they're now divorced. And they were divorced a number of years ago. What happened is, I guess for purposes of payment of the mortgage, there was one deed, right? So I forgot that. Went from husband and wife as a joint unified couple to, name of the gentleman, name of the lady, and they owned it as tenants in common. And, but really, she needed a deed, and the gentleman passed away. So now she doesn't know if he had a will. She doesn't know if he had any kind of estate administration proceeding, probate administration, otherwise. He passed away in Atlanta, and so that's the tale that we have. What's the moral of this story? Well, a couple of takeaways. When you get divorced, you should have a lawyer. If she had a lawyer at the time, I would believe that the deed would have gotten prepared, executed, and recorded at that time. It would have saved her a lot of time, effort, and trouble now. They did have children in common, but the children in common didn't inherit anything, or at least if there was a probate proceeding, those children had not been made aware of it. Now, according to New York law, the children would have had to be notified, would have had, right, they should have gotten notice. I don't know what the rules of Georgia are, but I would think it's kind of similar. They must have, I would think they should have gotten notice. In any event, the effort now has to be to locate or actually file something to obtain an estate representative. Because remember, the deed cannot come out of the gentleman's name because he's now deceased. He can't sign a deed. So, if you have a story like this, if you have a situation that needs to be addressed, please reach out to me. FrankBrunoLaw.com.